Good afternoon. This is Michelle Barki from Medcom Benefit Solutions. And for those who are joining us for the first time, I am Medcom Benefit Solutions Senior Legal Counsel. And there's a lot that's been happening over the past couple of weeks. And one of it is that we passed the Consolidated Appropriations Act of 2021. And there were a couple of provisions in there for FSAs and dependent care. So I thought we would go ahead and do a presentation today and get started with going through those changes. In addition, this broadcast is being recorded, and all of you will get a copy of the slide deck as well as a copy of the recording at the beginning of next week. And in the meantime, if you have any questions during the presentation, please do not hesitate to put them in the questions bar, and we will be addressing those at the end. And again, my name is Michelle Barki from Medcom Benefit Solutions, and let's go ahead and get started. What we're going to talk a little bit about today is what we already knew from Notice 2029 and 33 that were passed earlier this year, and how it fits into some of the changes of the Consolidated Appropriations Act of 2021. We'll also talk about planned documents and what needs to be done if you want to make any of these proposed changes. And then maybe just do a little bit on things to consider if you're deciding whether or not you want to make these proposed changes. These are some of the facts that you might want to consider. And then at the very end, I just want to touch a little bit on the Family First Coronavirus Response Act, because it has potentially been extended as well. So let's go ahead and get started and talk about Notice 2029 and 33. And at the very beginning of the pandemic, as you can remember, when it was declared on March 13th of 2020, we were all in a shutdown mode. Remember when we were looking at flattening that curve, and they told us that if we would just all stay home for 15 days, and then in some states that has continued to be, and other states did ease up gradually. But one of the things that we did know was that a lot of services were canceled. Elective surgeries were canceled. It was hard to get dental appointments or vision care appointments. And in some parts of the United States, it still is. And there was that fear that people were going to lose that FSA money that they had put in at the beginning of 2020, or they might lose that money specifically if they were a non-calendar year plan. So the IRS came out with Notice 2029, and they made a whole lot of adjustments to the FSAs and the DCAPs, and they basically allowed a lot of things to change. And some of those changes that they allow were all permitted. You did not have to change your documents. You did not have to elect to make these changes, but employers were given the option. And they were given the option to allow employees to make new elections on their FSA, whether they wanted to increase the amounts or decrease the amounts. They were given the option as to whether they wanted to revoke an existing election and to increase, and again, as we talked about, increase or decrease the amounts. And, you know, the same was true with the dependent care assistance programs, although we weren't as concerned about those as we were with the FSAs, because with the dependent care, there's automatically a provision in the Act that says if something changes during the year, you can always add or decrease the dependent care account. So for an example, if the spouse who was, one of the spouses decided to stay at home and take care of the kids, and the amounts that were previously elected were no longer necessary, you were always allowed to change that. But under Notice 2029, they made it very clear, just like they did with the FSAs, that you could continue to make new elections, revote existing elections, or increase or decrease the election amount. And again, these were all permitted changes to DCAPs and FSAs. And the employers were able to either offer this to the employees, or they might have decided that they did not want to. And, you know, at the very beginning, it really affected the non-calendar year plans for the most part. Calendar year plans, you know, it was a wait and see effort to see what would happen by the end of 2020. I know that in Florida, where I'm located, we opened up in July, and we've had opportunities to have our elective procedures and go to the dentist and go to the vision, but I understand that's not the way it is in a lot of parts of the country. And then we also have to consider how our employees feel about that, because there's still that varying degrees of fear. We also, under Notice 2029, had special enrollment rights for our health plan coverage as well, that we could either enroll or disenroll in the health plan if it was permitted by the employer. However, I also cautioned everybody at that time to be very careful and talk to the carrier, especially on fully insured plans, and the reinsurance carriers on self-funded plans, because while the employer might say, hey, this is a great idea, if the carrier did not allow somebody to enroll, it was kind of moot. But those were some of the special enrollment rights we were also having during COVID. But now we've come to the Consolidated Appropriations Act of 2021. This is the act that was passed by Congress a week ago, and that President Trump initially refused to sign, but he did sign it on Sunday night. So now this actually is going into effect. And basically what the Consolidated Appropriations Act did is it took a look at where we stood with COVID today at the end of 2020. And we do have an increase in COVID. The vaccines are about ready to come out, but that's going to slow it down only potentially in the future. But what do we do today and now? And part of that was they again made some changes, or they allowed some permitted changes in the FSA and the DCAP world. We recognized that we were all still reeling from the effects. You know, the ICU beds, I understand in California are at 0 right now, and we understand they may be in short supply across the country following the Christmas break. So if that's the case, then elective surgeries will once again be put on hold. And some states are still locked down, as we know, and to a varying degree, individuals are still terrified. And at the same time, a lot of us are going through open enrollment or went through open enrollment and didn't know what we wanted to do with the FSA accounts that were going to start on a calendar year basis. So the government has addressed some of these issues, and they came up with a very short and simple rules, and I think they're great. The first thing they said is, okay, for anyone that has an unused FSA balance from the plan year ending in 2020, if you want to allow your employers, you could roll over that full balance into 2021. We realized that with Notice 2033, that the carryover amount increased to $550, but what if that individual had $1,500 left in his FSA account? He can now, with the employer's change of the plan documents, and if the employer agrees to allow these changes, can roll over the full amount into plan year 2021. It basically extends the grace period for 12 months. You can take all the money you have left and use it in the plan year of 2021. It also permits participants who terminated sometime in 2020 to use all the amounts for the unused plan year that they did not use. So if you had an employee that terminated in February or March, you could have them go ahead and provide receipts for any medical expenses they might have incurred up to the end of this year. That would cover the rest of their FSA balance that they had when they terminated. Again, completely employer's option as to whether they want to allow these changes. And then DCAP, the only real change they had is they did recognize that maybe some of the children did term out during the pandemic. So you might have considered you had a 12-year-old child who was reaching 13, but you weren't able to use the monies that were there when she was 12. Well, they've now extended it to 14, just during the pandemic. So this is during this year, and next year, the age maximum could be up to age 14. So that's good news too. Might be a little difficult to send your 14-year-old to daycare. They might not appreciate that, but there might be some other use for those funds as well. And then the next thing that they said, okay, if we're allowing you to carry over your 2020 contributions into 2021, we know that the pandemic is still here. The national emergency hasn't terminated yet. So we are also going to allow you to do that for 2021 into 2022. So this, if the employer decides they want to do this, this is a great time to go back and maybe reopen open enrollment and say, you know, based on the fact that you won't lose any money at the end of the year, we're going to allow you to roll that money into 2022. You might have some unexpected expenses in 2021 due to COVID. Potentially, this is something that you want to take a look at. So again, not only did 2020 roll into 2021, but we can roll 2021 into 2022. And I like that because that's actually thinking ahead when you're looking at FSAs in the government. We're learning this at the beginning of the plan year for the most part, if it's a calendar year plan rather than the end. So basically extends the grace period 12 months into 2021. And it in 2021 into 2022. And it again allows any participant who terminates in 2021 to continue to receive reimbursement through the end of the plan year. And again, DCAP increases to the age of 14 for those who aged out during this pandemic. And then they also said right up the front, when somebody's electing on an FSA or a DCAP plan for 2021, that which is this current year coming up, if they want to do any prospective modifications of any of the election amounts throughout the plan year, they can do that, provided the employer lets them. So we do have that prospective modification again, and we know that right up front, and we also know that we can continue up until the end of the plan year, and we also know that if a participant terminates, that it can go to the end of 2021. So those are some really nice changes that will get us hopefully through the end of the pandemic, which they anticipate at the end of 2022. Now, we always are concerned about plan documents. I mean, here we are coming up to the end of the year. When do I have to have the plan documents amended by? And the government gave us plenty of time to do that. They said if you adopted any changes for the plan year commencing in 2020, you have until December 31, 2021 to amend. And any of the, if you have a plan document that ends anytime in 2021, you have up until December 31st of 2022 to amend. So basically, they're giving us enough time to decide what we want to do, how it's working, whether we want to add or subtract during the year, because we don't have to update our plan documents until the end. The government recognized right from the start the most important thing was to get the benefits in place that would be best for the employees and worry about the documentation and the plan docs and all the ERISA qualifications later on. So it does give you some time. I would always recommend that you get it done sooner than later, but again, there is time to do it. So, you know, some of the things to consider when you're deciding whether or not you want to offer any of these changes to your employees, or if you want to recommend any changes, is do the participants live in states that have some degrees of lockdown? So, you know, when you're looking at New York and California and Chicago and Illinois and some of those states that are still on a pretty stringent lockdown, and they still don't have elective surgeries going on right now. And we're coming into open enrollment, or maybe just past it, and maybe people didn't want to register because they were afraid of losing money at the end. Now is the opportunity to say, hey, you know, we understand the issue. You can roll 2020 into 21 and 21 into 22. So that should alleviate some of the concerns, or you can also make those prospective changes. Is it a calendar year plan? Because if we're coming into the calendar year, that's really nice to know. And if it's a non-calendar year plan and the benefits terminate March or April, this gives you that additional time to use the money if the employer so desires to allow them to do that. Then you also want to talk to your third-party administrators and how does this affect them and what they can do to help you out and what would the fees be, if any, and how you want to make sure that this all fits together. And do you want to prepare 2020 only and wait to see for 2021, or do you want to do it all at the same time? You know, I don't know what it looks like yet. I don't have any numbers as to how many people are electing in 2021, worried about not being able to go to the dentist or the vision or to getting elective procedures, but this might increase the enrollment and the tax savings for 2021 if some of these changes are allowed. So those are some of the considerations that you might want to think about when determining whether you want to do this or not. The next thing I want to talk about is the Families First Coronavirus Response Act. You remember this? This is if you were under 499 employees or any size, if you were a public employee, you had to pay up to 2 weeks of 80 hours at 100% of the salary. If you, for any coronavirus symptoms or for any coronavirus diagnoses. And this was because, of course, we don't want people in the workplace who might have COVID and spread it to everyone else. Now, I know we have a lot of at-home workers now, but the law still applies. And then it did allow for paid sick leave. It did allow also for family medical leave. If the daycare was closed or the schools were closed, then you could also get expanded family medical leave and get 10 weeks paid at 2/3 of your salary. And then the government reimbursed for that amounts that the employees were spending. Well, it was originally set to expire on December 31st, 2020, later on this week. However, the government has decided to extend that to March 31st, 2021. But it is the employer's choice. You do not have to allow it, but you can allow it to be extended through March 31st. The tax credits will still be available. However, the maximum time is the maximum time. You can't say you get 2 weeks of paid sick leave in 2020 and then another 2 weeks from March 31st to up to March 31st of 2021. It's 2 weeks period. So those who have not already used it could potentially use it up to March 31st. But again, that's employer's choice. And then we'd have to consider how we notice the employees on this. There has been no guidance of this. And again, whenever a law is passed, the law is passed basically in a very rudimentary format, and then it goes to the departments to formulate any other rules or any other notice requirements. So those are basically where we stand today with these two acts. And I do see that we have some questions. And it says, if the employer allows the employee to continue and they did not elect in 2021, is an administration fee charged for that individual? I think that's something you have to talk to your TPA about. I do not believe that we charge anything for an individual if there's no election. I think our fees are based on the elections and how many people actually elect. And does the extension to incur expenses through the end of the plan year for terminated employees apply to both FSA and DCAP or just FSAs? It actually applies to both, and you can certainly allow that to happen. And are there any changes to the HRAs? At this stage of the game, the government just said it was for FSAs and for DCAP plans. They did not mention HRAs, so that did not come out. And what if your plan year ended on October 31st? Well, if your plan year ended on October the 31st, you can extend the payments or you can extend the ability to use it up until the plan year terminates on October the 31st of 2021. And then from October 21 through October of 22. So it would go by the plan year. But yes, you could allow the employees to spend the monies up until the end of the plan year for the 21 and 22. Then the other question I have is, please explain the terminated employees options again. Are terms for 2020 eligible to continue utilization funds through the end of the 2020 year only, or can they roll over the funds to 2021? If you terminate, you can only use the funds up to the end of this year. Is basically what it says at this point. There might be some clarification down the road. And then if anybody is still an active employee and enrolls in 2021, and terminates in February, then they could use it up to the end of the 2021 plan year. But it doesn't roll over. But I'm thinking about some of those employees that might have quit in March or April of this year, whether or not you want to go back and allow them to submit receipts up until the end of this year. That's what the whole idea was supposed to be about. Employees can still elect the full IRS amount allowed for health and decaps in 2021 and 2020. Yes, technically, if you have prospective election changes and you were allowing people to prospectively elect, and somebody wants to prospectively elect for another week in 2020, considering that it might be a rollover of the full amount, if the employee wants to do that, yeah, I can see that happening. They'd have to do it pretty quickly, and you'd have to get the employers to put this in place pretty quickly. And yes, they could also in 2021, they can prospectively change the amounts. And again, these are all permitted election changes. So employers don't have to let this happen, but yes, they could. If an employer wants to extend the age for the decap to 14, do they have to amend their plan doc for the terminated employees? Do they have to amend their plan doc? Yes, they would amend their plan doc to 14. It would be a pretty simple change. And again, they have a year to do so basically, because the IRS has given us a lot of time to do that. Or it might be just a SMM that you do. But we can certainly talk about the best way for the employer to do that. And again, we always recommend that you take a deep breath. Don't try to do it all at once, just in case other changes are coming down the pike. That's why the IRS is giving us this opportunity to make sure we really know what we want as we go about doing that. For the terminated employees, they have until the end of 2020. Is that the end of the 2020 calendar year, the plan year? It looks like that would be at the end of the 2020 plan year, so that everything always goes by the plan year, and it would be at the end of the 2020 plan year. And then will the CAA result in the employees being able to accumulate more than 5K in their decap? Mark, that is a really good question, and I'm going to have to take a look at it. The government did not say anything when they actually put this in the rollover or into the law, but I will take a look at that before I commit on that. And that is a really good question. But I'm really glad that the government came out with some of these changes now, rather than in March or April. It gives us all something to think about as we start a new calendar year and deciding what we want to do during this calendar year. So I think that that's all the questions that we have today. And again, my name is Michelle Barki with Medcom Benefit Solutions. And if you have any other questions, please do not hesitate to get in contact with me, and we'll start working through some of these questions or more if they come through. And I'm still waiting for some more guidance from the IRS and the Department of Labor. As always, when these laws are passed, they're passed in their very rudimentary forms, and sometimes further guidance comes out. Let me tell you, this act that was passed was over 5,000 pages. So there's still a lot of information to go through, but that's what we found out for the FSAs and for the decap. Again, as I mentioned at the beginning of the presentation, you'll all be getting a copy of this next week. And I want to thank you all for participating. Thank you. Bye.